My name is Julian Arato, and I'm a professor of law at the University of Michigan in Ann Arbor. I'm delighted to be here at NUS Law as the visiting Sat Pal Khattar Professor. American trade policy right now, at the beginning of 2026, is in a really difficult place. It's a moving target, hard to identify exactly where things stand. Obviously, since 2025, there has been a real break in the way that the US government has approached its international trade commitments. But right now, things are in a halfway house, in purgatory, because the US Supreme Court has invalidated much of President Trump's signature tariff actions. So the question of where things stand right now is a difficult one, but what I can say is clear is since the beginning of 2025, the US trade policy has been in a really different place than it was in the nearly century preceding it. For 80-something years, the United States government has pursued an open policy of trying to reduce trade barriers all over the world. And all of a sudden, in 2016 and especially in 2025, the US has returned to a protectionist posture, imposing tariffs on all countries all over the world on relatively thin legal grounds. Those direct tariffs right now are in some flux because of the Supreme Court decision, but I have no doubt that President Trump and his administration will be trying to reimpose all of those tariffs under various different authorities. Indeed, they already have. Quite frankly, the answer is a simple one. The United States has made ample commitments under international law to reduce its tariffs through the World Trade Organization, a body that the United States was one of the greatest advocates in creating. And these commitments extend back to the 1947 General Agreement on Tariffs and Trade. All of President Trump's tariffs are in flagrant breach of those commitments right now. So as a simple matter of international law, the United States is in breach. The United States is ignoring its commitments, and in fact not even attempting to justify its recent tariffs in terms of international law, in terms of exceptions to the normal rules, in terms of other types of reasons or rationales why such tariffs might be appropriate. So not only is the United States in breach of its international legal commitments it created, it's in flagrant breach without any attempt to justify things in terms of international law. Yeah, so I think there's a temptation to see things right now in terms of US trade policy as a complete about-face, a break with the post-war international legal order that the United States promoted and indeed was the leader in creating. And to an extent, there's some truth to that. 2025 represented a major rupture in international trade law and in the United States' approach to international trade policy. Never before had a United States president since 1945 imposed tariffs on all of its trading partners for no real reasons offered, no substantial reasons offered. And yet what I want to suggest in the lecture is that the moment of 2025, serious and problematic as it is not one purely of rupture. It's a moment of continuity in other ways as well. Because for a long time, the United States has been pushing the envelope of what exceptions it can employ, of where it can legally engage in certain kinds of protectionism within the rules since the beginning. It happened in waves right after the 1945-1947 creation of the General Agreement on Tariffs and Trade. In 1945 to 1947, the United States was absolutely serious about creating a world order in which states would be held to account for failing to live up to their commitments to liberalize trade across the world. And the US took those commitments seriously. The US had a deep and important idealism from the beginning. But over time, the US drifted into finding avenues, opportunities to engage in protectionism through the legal rules, through exceptions to the legal rules in the system in various ways. And as it began to engage in those kinds of exceptions-based protectionist maneuvers, it started doing it more and more, trying to advance interpretations that would expand those windows and create more opportunities to renege on its commitments. It went back from some of this in 1994 in advocating for the World Trade Organization and really serious dispute resolution within that system. But shortly after the creation of the WTO, a monument to multilateralism, the US reverted to its unilateral ways through its anti-dumping practices, through its approach to the procedures and rules of international dispute settlement, and through its invocations, ever more frequent, of the national security exception in the WTO. What I'm commenting on in the lecture is the United States' effort to promote a world trade law that would be binding on all, and yet reserve for itself the capacity to act unilaterally around the edges of that law in order to make sure that when it needed to, or when it felt it needed to, it could protect its domestic companies. And over time, it began to use those unilateral options more and more and assert wider and wider authority to do so. So when we come to 2016, the first Trump administration, there was obviously a moment where many thought that the US had reverted away from free trade all of a sudden in a snap. But here we see the United States engaging in the same kind of unilateralism it had been doing before, justifying its measures in terms of international law, but doing so more and potentially more aggressively, more abusively. What's different in 2025 is now the United States does not even justify its unilateralism in terms of international law. It ignores the law and attempts even to destroy the institutions in which that law is housed. So no one can predict the future, and I'm certainly not here to suggest where I think United States trade policy will be going over the next few years. What I can say is that I hope we will be able to pick up the pieces and return to a more serious multilateral form of trade governance, one in which the United States views itself as an equal partner to the rest of its trading partners, not preeminent partner among many. What it's going to take is not only abandoning the current ethos of America first, but really looking in the mirror and reconsidering the ethos of American exceptionalism, an ethos which we've had with us for a century, in which the United States has, in its own self-conception, been a part of a society of equals, but preeminent among those equals. To pick up the pieces, we're going to have to create a new form of an international, multilateral legal system to govern international trade, but one in which all partners are on an equal footing.